Chapter 8. Parties Defendant. SS 128. Debtor as defendant in creditor's actions. The doubts and difficulties incident to the selection or joinder of proper parties are not restricted to the class of complainants, but, on the contrary, cases of alleged misjoinder and non-joinder of defendants are frequently up for adjudication in different forms. As a general rule, all persons participating in making a fraudulent conveyance are proper parties to a suit to set the transfer aside. It is a general rule that all parties interested in a controversy, or who may be affected by a decree rendered therein, should be made parties. All who are nominally or really interested may therefore be joined, although the interests of all may not be affected alike by the relief which may be granted. Let us briefly look through the authorities. The question of the necessity of joining the grantor or debtor as a party defendant in an action brought by a creditor to secure a discovery of assets or cancel a fraudulent conveyance is involved in some obscurity and confusion, and the authorities relating to the subject must be carefully distinguished and classified. Professor Pomeroy says that in an action by a judgment creditor to reach equitable assets of the debtor in his own hands, or to reach property which has been transferred to other persons, or property which is held by other persons under such a state of facts that the equitable ownership is vested in the debtor, the judgment debtor is himself an indispensable party defendant, and the suit cannot be carried to final judgment without him. The statement of the matter is, as we shall presently see, entirely too general and sweeping. In New York, the necessity for making the debtor a party defendant is made to depend upon the nature of the particular proceeding. In Miller v. Hall, the action was brought to have an assignment of a bond and mortgage made by the debtor to the defendant declared fraudulent and void as to creditors. The New York Court of Appeals held that it was well settled, in the case of a creditor's bill to reach a chosen action, which was the character of the suit in question, the judgment debtor was a necessary party. The earlier authorities show that the practice of joining the debtor prevailed. In Shaver v. Brainard, the action as in the nature of a creditor's bill brought by a receiver to set aside a conveyance of real estate as fraudulent, and apply the proceeds upon the plaintiff's judgment. The grantor and judgment debtor was not made a party defendant, and the judgment was reversed for that reason. In another case, where a receiver filed a bill against a trustee of the debtor to reach equitable interests of the latter in a trust fund, the debtor was declared to be a necessary party. In Haynes v. Hollister, the assignee of an insolvent firm, the personal representatives of a deceased partner, and the surviving partners were held to be properly joined in a creditor's action to compel an accounting by the assignee, and to recover of the representatives the balance of the plaintiff's claims. In Lawrence v. Bank of the Republic, the court observed, in a creditor's suit against a judgment debtor to set aside a prior assignment made by him in trust for the benefit of creditors, on the ground of fraud, he is a necessary party. Indeed, he must be deemed the principal party. Otherwise, different persons, claiming portions of the assignee's property, could not be joined as defendants. The common point of litigation is the alleged fraudulent transfer of the property. The case of Gaylords v. Kelshaws is sometimes cited as an authority for the proposition that in any form of action to annul a conveyance as fraudulent, the debtor must be summoned. The court said that the debtor was properly made defendant to the suit, as it was a debt which he owed which the creditor sought to collect, and it was his insolvency that was to be established, and his fraudulent conduct that required investigation. It was expressly held, however, that it was not necessary to decide whether the suit could proceed without him, because as matter of fact he had been found in the district and had answered the bill. Miller, J., said, "It is simply the case of a person made a defendant by the bill, who is also a proper defendant, according to the principles which govern courts of chancery as to parties, and who has been served with process within the district and answered the bill, but whose citizenship is not made to appear in such a manner that the court can take jurisdiction of the case as to him. In an action for unpaid subscriptions, a judgment creditor may join all the stockholders, or if they are too numerous he should so allege in the bill, and the corporation may be joined. SS 129. When debtor not necessary defendant. Fox v. Moyer is an illustration of a case in which the debtor is not a necessary party defendant. The plaintiff was a judgment creditor with execution returned unsatisfied. He claimed that his judgment was a lien upon certain real estate which one of the judgment debtors had fraudulently conveyed to the defendant, and he commenced this action to have the cloud resting on the lien of his judgment removed, and to have his judgment satisfied out of this land, notwithstanding the conveyance. Earl C., in delivering the opinion of the New York Commission of Appeals, said, "The conveyance was good, as between the parties thereto, and hence no one had any interest to defend this suit but the defendant. And he was therefore the only proper party defendant. Fox v. Moyer was relied upon by the plaintiff's counsel in Miller v. Hall as controlling, but the Court of Appeals said that the former case was not a creditor's bill and was plainly to be distinguished from the other cases which we have noticed. In Buffington v. Harvey, it was urged that the assignee's bill was defective because the bankrupt was not joined. Bradley, J., after remarking that the bankrupt had no interest to be affected except what was represented by the assignee, said, as to the bankrupt himself, the conveyance was good. If set aside, it could only benefit his creditors. He could not gain or lose, whichever way it might be decided. In Potter v. Phillips, the court said that though the debtor was a proper party, it did not see why he was to be regarded as a necessary party. Whether the conveyances were fraudulent or in good faith, the property irrevocably passed beyond his control. He could be prejudiced in no way, in a legal sense, by a determination which subjected the property to the payment of his debts. So it was decided in Minnesota that where a creditor sold land which the debtor had fraudulently alienated, the fraudulent grantee might bring an action against the purchaser to determine his title without bringing in the fraudulent grantor. It is remarked in some of the cases that the fraudulent grantor should be joined because it is his conduct that is to be investigated. The Supreme Court of Mississippi observe, however, that the object of the proceeding is to reach property, not character. In truth, the proceeding is in rem. And while the complainant may, if he chooses so to do, join as defendants all who are connected with the property or the transactions to be investigated, he is only compelled to join those in whom the legal title vests, or those who have a beneficial interest to be affected. Cases are cited in consonance with this reasoning. What inference then is to be deduced from this mass of authority? And which class of cases embodies the best logic? Should the debtor be joined as a defendant in an action to annul a fraudulent transfer? The best reasoning of the authorities seems to establish the rule that the debtor's presence as a defendant is superfluous in suits brought against fraudulent alienees to annul specific covenants conveyance. The transfer is conclusive upon him, and hence his joinder cannot aid the creditor or benefit the debtor. The suit is a proceeding in rem to clear the title to the property only so far as the creditor's needs may require. Under established principles of law, the debtor can gain nothing by it. He is practically a stranger to the property, nor can he be prejudiced by a decree which applies the property to the payment of a fixed judgment debt. On the other hand, where the suit prosecuted is purely a creditor's bill embodying the elements of a bill of discovery, the debtor's presence would seem to be essential to the jurisdiction of the court. The practitioner must be careful to distinguish between an action instituted to reach specific property fraudulently alienated and a suit brought to discover equitable interests which are not subject to execution, and the title to which is in the debtor. In the latter case, the debtor must of necessity be a defendant, especially should the complainant make the debtor a defendant where it appears that parties holding separate property under distinct conveyances are joined. In such proceedings, the debtor constitutes the kingpin of the action. In any case, it is the safer and more prudent practice to summon the debtor as a defendant, for a vexed question is then put at rest, and the misfortune similar to that which overwhelmed the creditor's representative in Miller v. Halley will be averted. SS 130. Defendants need not be equally guilty. As a general rule, where the subject matter of a suit is real or personal property, and the purpose of the plaintiff is to set aside fraudulent judicial proceedings in reference to it, the complainant should make all persons parties who are actors in the proceedings, especially if they claim a present interest in the property in dispute. The complaint so framed is not demurrable on the theory that there is an improper joinder of several causes of action against different persons. On the contrary, it is regarded as a single cause of action affecting all the defendants. Westcott, J., in delivering the opinion of the Supreme Court of Florida, very appropriately says, "It is apparent from the case stated that all of the defendants were not jointly and equally concerned in each distinct fraudulent act charged. There was a series of acts in this well-conceived network of fraud, all terminating in the deception and injury of the plaintiff. The defendants performed different parts in the drama. These acts affected the property of the debtor, some the personal property, others the real estate. The object of the plaintiff in this complaint is to get the assistance of this court in unraveling this network of fraud in respect to each species of property, and to have a due application of the same to the payment of the claims of creditors. The right of the plaintiff is against the whole property, and his right against all portions of it is of the same nature. The decree in chancery and the sale thereunder are but acts of fraud. which are sought to be set aside in order to enforce this general right. In fact, the right to set aside these proceedings can only coexist with an equity affecting the property which was the subject of them. There can be no such thing as an equity or right to set aside these proceedings distinct and independent of rights and equities attached to the subject matter that they affect. The result is that these are not several causes of action, but are acts which, connected with the debt due plaintiff, constitute a ground for one action alone. SS 131. Fraudulent assignee or grantee must be joined. A judgment as a general rule only binds parties and privies, as the property which is the object of pursuit is usually in the hands of a transferee. It follows that such person must be joined as defendant, so that he may be affected and concluded by the judgment. The proceeding would be futile if it omitted him. It was accordingly held, in a case where a creditor's bill was filed to reach monies due upon a mortgage which was alleged to have been fraudulently assigned by the debtor, that the assignee of the mortgage, although he resided out of the state, must be joined as a defendant. Parties to intermediate conveyances need not be joined, nor grantees pendent light, for they stand in no better position than those under whom they claim. In a suit to set aside a fraudulent conveyance, there is no necessary inconsistency in averring the grantee to be a fictitious person, and stating that the deed in his name was made to hinder and defraud creditors. SS 132. Joining defendants. The rules with reference to the joinder of defendants will be noticed somewhat at length in discussing the subject of complaints bad for multifariousness. The cases there reviewed seem to establish the principle that different fraudulent purchasers of distinct pieces of property may be joined as defendants. In such cases, the debtor is a necessary party, as he is the very link which unites them all together, the common center to which they are all connected, and it is because he is a party defendant that they can all be joined in one action as co-defendants. The defendants in such cases are said to be united in a common design. Each is charged with colluding with the debtor in order to defraud his creditors, where there is one entire case stated. As against the debtor, it is no objection that one or more of the defendants to whom parts of the property have been fraudulently conveyed had nothing to do with the other fraudulent transactions. The case against the debtor is so entire that it cannot be prosecuted in several suits, and yet each of the defendants is a necessary party to some part of the case stated. If, however, the party reached and made defendant has a remedy over against other parties for contribution or indemnity, it will be no defense to the primary suit against him that such persons are not made parties. A creditor might never get his money if he could be stayed until all the parties who were obligated could be made to contribute their proportionate shares of the liability. SS 132A. Conveyance pending suit. The law is established that a party who intermeddles with property in litigation does so at his peril, and is as conclusively bound by the results of the litigation, whatever they may be, as if he had been a party to it from the outset, where the rule otherwise endless entanglements would result. SS 133. Assignee and receiver as defendant. In a case which arose in New York, in which the assignee of an insolvent copartnership had been joined as defendant, the Court of Appeals said, as this is an equity action, the assignee of the firm, who had received its assets and never rendered any account for the same, was a proper party. He represents the firm, stands in its place so far as property is concerned, and the avails of the same in his hands are first liable to be appropriated to pay the demands of the plaintiffs. No valid reason exists why a person thus situated is not a proper party, in connection with the survivors of the copartnership and the representative of the deceased partner, if an action is brought by a judgment creditor to reach property fraudulently alienated. The fact that the debtor has made a general assignment for the benefit of creditors is no defense to the debtor or to his fraudulent alienee, because they can have no interest whatever in the fund, and are not vested with the right to guard any interests the assignee may possibly have. It is the assignee's exclusive privilege to personally assert such rights. Furthermore, under some circumstances, the creditor may maintain an action in his own name to set aside a fraudulent conveyance, even though the assignee has the same right, if it can be shown that the assignee is in collusion with the fraudulent parties, or has refused on proper request to become a plaintiff. In any case, the defense of the non-joinder of the assignee to be available should be taken by demurrer or answer, disclosing the names of the omitted parties, or it will be considered waived. SS 134. Objection as to non-joinder. How raised? Duran v. Hankerson is perhaps an extreme illustration of this latter proposition. That action was prosecuted by a creditor to cancel a deed. The conveyance was held to be good, but it appeared that the debtor had taken back a mortgage upon the property, which remained unsatisfied. and the evidence tended to show that the debtor had assigned the mortgage to a person not a party to the suit. It was proved and found that this assignment was fraudulent, and the purchaser from the debtor was directed to pay the mortgage to a receiver. The purchaser strenuously resisted this decree, upon the ground that the pretended assignee of the mortgage, not being a party, was not bound by the judgment, but the learned Woodruff, J., held that while it presented a case of possible hardship, as payment might perhaps be enforced a second time, yet the purchaser should have protected himself by raising the objection in the manner prescribed by law. The defendant, who neither by answer nor demurrer takes such an objection, waives it, and therefore cannot afterward be heard to object on that ground to any decree to which, upon the facts alleged and proved, the plaintiff may be entitled. The cause thereafter proceeds, as to him, with the like right in the plaintiff to a decree as if the supposed proper or necessary party had been brought into court. We may here observe that the appointment of a receiver does not absolutely dissolve a national bank, and that in an action to establish the rejected claim of a creditor, the bank and the receiver may both be made parties defendant. SS 135. Misjoinder of causes of action. The cause of action against sureties upon the bond of an administrator, claiming a breach of its condition, cannot be united in the same complaint with a cause of action arising out of the fraudulent disposition of property against the administrator of the deceased intestate and others. SS 136. Executors, administrators, heirs, and legatees. We have already considered the status of personal representatives, heirs, and legatees as complainants. Let us briefly advert to the question of their joinder as defendants. In Allen v. Vestal, it was said that a creditor, in an action to set aside a fraudulent conveyance to heirs of a deceased debtor, should allege that the personal property had been first exhausted, and should make the administrator a party, or, if there was none, should secure one to be appointed. This is but another phase of the general question as to the necessity of joining the debtor as a defendant. Authorities can be cited to the effect that the administrator is not a necessary party to the creditor's proceedings, and to the opposite effect, and holding that heirs need not be joined, and, in New York, as is elsewhere shown, a distinction is made as to the form of the action, the debtor being a necessary party in a creditor's action, but not in a suit in equity to remove a fraudulent cloud. Where this distinction is recognized, it might be extended to cover the cases of personal representatives and heirs. The United States Supreme Court leans to the view that, in a suit to charge real estate with the payment of a debt, the heirs and devisees should be made parties to the bill. In a creditor's bill under which an executor had been removed from office, the Supreme Court of South Carolina held that the legatees were necessary parties, and that the receiver appointed in the place of the deposed executor did not represent them. Again, the Supreme Court of Ohio has decided that where the grantee dies after the rendering of a decree in favor of a judgment creditor setting aside a conveyance and ordering a sale of the property, but failure to revive the decree against the heirs of the grantee did not affect the title of a purchaser under the decree. What then is the result of the cases upon this point? Necessarily much the same conclusion must be reached as is gathered from the authorities upon the question of the joinder of the debtor in an action to reach assets in the hands of a third party. We have already seen that the personal representatives may, in certain cases, annul covenants alienations made by the deceased, but only so far as may be necessary to satisfy creditors. In states where the right of the creditor to seek direct relief is upheld, it is difficult to see why the personal representatives or heirs should be joined. The conveyance is conclusive upon such parties, and their presence in the suit will neither aid the creditors nor benefit them. SS 137. Trustee incestuique trust. Mr. Pomeroy says, there is a broad distinction between the case of an action brought in opposition to the trust, to set aside the deed or other instrument by which it was created, and to procure it to be declared a nullity, and that of an action brought in furtherance of the trust, to enforce its provisions, to establish it as valid, or to procure it to be wound up and settled. In the first case, the suit may be maintained without the presence of the beneficiaries, since the trustees represent them all and defend for them. The Supreme Court of Georgia, adopting this general rule, held that where a creditor claims not under but in opposition to a deed of trust made by his debtor, and seeks to set the same aside on the ground that it is, as to him, fraudulent and void, he is at liberty to proceed against the fraudulent trustee who is the holder of the legal estate in the property, without joining the cestuique trust. A decree setting aside the deed, or charging the property with the creditor's demand, will, if fairly and honestly obtained, conclude the cestuique trust as being represented by the trustee, but is subject to be impeached for fraud or collusion. SS 138. Party having lien. It certainly is reasonable, and seems to be recognized as an established rule, that where a party has a lien, by way of mortgage for example, upon the property which is the subject of contention, and no ruling is asked against such lien, and it is not assailed, but the title under it is conceded to be valid, there is no ground upon which the holder of the lien can be regarded as a necessary party to the suit. The creditors, having elected to avoid the fraudulent conveyance, take the property as though the transfer had never been made, and subject to all lawful liens upon it. But where the lien holder is made a party to the suit, and the validity of his claim is investigated and disposed of by the judgment adversely to the validity of the lien, a sale by the receiver will transfer to the grantee a title superior to such lien or claim. SS 139. Stockholders. The assets of a corporation are, as we have seen, regarded as a trust fund for the payment of its debts, and its creditors have a lien upon it, and the right to priority of payment over its stockholders. Hence, where property of a corporation had been divided among its stockholders before its debts had been paid, the court decided that a judgment creditor, with execution returned unsatisfied, could maintain an action in the nature of a creditor's bill against any one stockholder to reach whatever had been received by him, whether wrongfully or otherwise. It is unnecessary to make all the stockholders defendants. The question of the statutory liability of stockholders to the creditors of a corporation where the capital has not been all paid in and a certificate to that effect filed as required by statute has given rise to much litigation in New York and other states where such provisions exist. This liability is said to rest in contract. The statute in effect withdraws the protection of the corporation from the stockholders and holds them liable as copartners. If the liability was penal, the statute could of course have no operation in another state, and for penal statutes are strictly local in their operations and results. Hence it was held that, as the obligation imposed upon a stockholder under the New York statute rested in contract, it could be enforced in Florida, the rule being that a transitory action may be brought in any court having jurisdiction of the parties and the subject matter.